Hello. So, welcome to the webcast for the Syracuse Intellectual Property Law Institute. This is Professor Shubha Ghosh, and I'm going to give you a brief discussion about the oral arguments in Iancu versus Brunetti that was heard by the Supreme Court on Monday, April 15th. I was able to attend, and I wanted to give my brief thoughts about the oral arguments and about the case more broadly. And so the title of this webcast is Iancu versus Brunetti, the First Amendment and Trademark Battle Continues. And the Brunetti case is a follow-up to the Supreme Court's decision in Mattal versus Tam in 2017. At issue in Mattal versus Tam was the Lanham Act Section 2A provision giving the USPTO the power not to register disparaging marks violates the First Amendment. So the basic idea here is after the Mattal versus Tam decision, the provision of Lanham Section 2A having to do with the ability to not register disparaging marks is unconstitutional. And so there's been a lot of discussion about whether the statute will be rewritten, whether there's a way to recast the statute so it is consistent with the First Amendment. But the court did strike it down. And so this put to rest the Redskins litigation that was going on regarding the cancellation of the Redskins trademark as a disparaging mark. The Tam decision basically meant that disparaging marks can't be a basis for not registering a trademark. And so in the Mattal versus Tam decision, the court unanimously found that the provision was impermissible viewpoint discrimination. And so basically, first of all, the decision was 8-0 because there was the vacancy that hadn't been filled yet with the Gorsuch appointment. And the remaining 8 justices agreed that this was impermissible viewpoint discrimination. In other words, what the PTO was doing by saying, well, a particular mark is disparaging, therefore not registrable, was discriminating based upon viewpoint. It was see the viewpoint discrimination in lots of ways. One way to say it is that if the mark was saying something favorable about a group, then that viewpoint would be okay. If the mark was saying something negative, then that viewpoint would be viewed as not okay for registration. And so that was a basis to say viewpoint discrimination. And so once something is found to be viewpoint discrimination, the question is whether the government had a compelling interest. And the court concluded that the government did not have a compelling interest to basically allow non-registration of disparaging marks. Now, there's an 8-0 opinion. There were 2 separate sets of opinions, one with Justice Alito and then one with Justice Kennedy. And the court did split 4-4 on this, with Breyer, the liberal, switching over to the conservative side on this, siding with Alito, and Kennedy writing the opinion for the remaining 4 justices, Sotomayor, Ginsburg, and Kagan. And so it's kind of an interesting split. Basically, the difference between that split was that the Alito opinion wanted to go a little bit deeper into the question about whether this is government speech, and they ruled that it was not government speech. And the Kennedy opinion basically said, well, we don't need to get to the issue of government speech, and we can just simply decide this case on the fact that it's viewpoint discrimination. So the trademark at issue in the case was the word slants, which the USPTO denied registration for because slants is a pejorative term for certain Asian Americans. And basically Tam was the leader of a group, rock group, music group that was Asian American, and they wanted to reclaim the word slant to take away its disparaging meaning. Even though that rationale was not part of the decision at all, that was Tam's kind of justification for why he chose slant. And now it was, I think it has been granted trademark registration since the decision. So Iancu versus Brunetti is the follow-up. The oral argument was on April 15th before the U.S. Supreme Court, and the issue there is the provision permitting denial of registration for immoral or scandalous marks in violation of the First Amendment. So this is now looking at the other parts of Section 2A of the Lanham Act TAM dealt with the disparaging mark provision, and Brunetti is addressing the denial for immoral or scandalous marks. And so the question before the court is whether the provision is facially unconstitutional as opposed to unconstitutional as applied. I mention this because it's not clear exactly how the court might go on this. Technically, the question is really, is it on its face unconstitutional? In other words, is there no application of the statute that would satisfy the Constitution? It may be that the court will reformulate the question as one of as applied. The court sometimes does that, but it's important to keep in mind that the real question is whether it's on its face unconstitutional. And the mark at issue is FUCT for clothing. The word sounds a lot like, I think as one of the government attorneys put it, the past participle of a fairly offensive term. So you can pronounce it for yourself if you want, but it was found to be scandalous or immoral by the USPTO and therefore denied registration. So the Federal Circuit ruling, and this is the ruling that's the one that's on appeal here, it was basically going back and forth in light of the TAM decision. But the Federal Circuit ruling found the provision impermissible content-based regulation that violated the First Amendment. So it did not just simply follow TAM, which was based on the notion of viewpoint discrimination. Here, the court decided it on content-based regulation, which is subject to strict scrutiny. Content-based is a very controversial concept. There is some debate about what that means. Extreme view that is everything is content-based, but the basic idea is that, as a practical matter, if the government has to look at the content of speech in order to impose the regulation, then it's content-based, and that creates a problem with the First Amendment. And so here, in order to determine whether the trademark is registrable, the USPTO, i.e. the government here, has to look to see whether the trademark is immoral or scandalous, which involves looking at the content of the trademark and then decide whether it is registrable. Content-based, strict scrutiny, meaning the government has to have a compelling interest, and so the Federal Circuit found that the government had no compelling interest here, and for various reasons, which I won't go into here. It's interesting for the characterization of content-based regulation. I mean, arguably, every provision in the Lanham Act has some content-based aspect to it. But if every provision of the Lanham Act was subject to First Amendment scrutiny, most likely what would happen is some of it would require, most of it would have a compelling interest in order to prevent, for example, consumer deception. Here, in the case of 2A, the Federal Circuit basically said the court is just simply saying we don't like certain types of speech because we find it immoral, we find it scandalous, and therefore we're going to deny the protections of registration. Content-based, no compelling interest, therefore unconstitutional. Now what's interesting is that the Federal Circuit also ruled that there was substantial evidence to find the mark FUCT as scandalous. So in other words, there was a basis to find it scandalous, even though that determination is content-based without a compelling government interest and therefore unconstitutional. And I mention that here because there's a lot of discussion about maybe the court should look to see whether the provision under 2A is vague and therefore unenforceable under the Constitution, or maybe it's overbroad, so there are these doctrines of vagueness or overbreadth. And the Federal Circuit seems not to go down that path. That doesn't necessarily mean the Supreme Court can't pick up that line of argument, but it is interesting that the Federal Circuit ruled that there was substantial evidence, meaning that there is some standard for finding that this particular mark was scandalous. It wasn't just simply a vague determination and so forth. And some of the things that the USPTO looked at was dictionary usage, a societal view of the scandalous term, urban dictionaries, and things like that. So why did the court grant cert? That's an interesting question that's worth spending some time on. The TAM decision was only 2 years ago, and now it's deciding another case. So there are three probable explanations. The these are just hypotheses here. We really won't never know why it granted cert, but its final decision might give us some clue, and asking the question might also give us some hint about how we predict the court might come up. So maybe it was just trying to clarify its decision in TAM. It was an 8-0 decision with two different opinions, and so maybe the court wants to take another shot at this issue and maybe come up with a stronger view about First Amendment and trademark law. Another view is that it might want to expand its First Amendment analysis of trademarks, so it might want to have a broader theory than either viewpoint discrimination or even maybe content-based. So the third possibility, of course, maybe it wants to contract its First Amendment analysis of trademarks. Maybe it'll find that the immoral or scandalous provision of 2A is constitutional, even though the disparaging portion is not. And that's fairly interesting. I mean, there was some argument, from some pushback against Brunetti here, especially from Justice Breyer, who was really concerned about, there are a lot of things then that if we strike down 2A, that probably would be registered. I mean, we give the example of the N-word. We give an example of other terms that are just sort of vulgar, that generally people would think is vulgar, not particularly distinctive, but still, would survive First Amendment scrutiny. So maybe there is a distinction. Maybe the court possibly wants to create some sort of stopgap that would allow the USPTO to deny certain registrations for things that it might find troubling. Well, now, how it squares the circle, reconciling its decision in TAM with allowing for the FUCT mark is an interesting question. We'll talk a little bit about that in a minute, but it may be very difficult for it to do that. But in theory, in practice, it's possible for the court to just come up with kind of two different standards under the Constitution for disparaging marks, viewpoint discrimination, and then for immoral and scandalous marks. And it might just find that the government's interest is more compelling for immoral and scandalous marks, and thereby contract the First Amendment analysis of trademarks for those types of marks. So let me conclude by giving you a sense of predictions. I think there are three possibilities. One, of course, is to follow TAM on viewpoint discrimination. That may be where the justices can come out. There was unanimity before on that issue. Maybe there'll be unanimity now, again with a 9-0 decision. And again, not getting into some of the extraneous issues like they did last time, such as government speech. So maybe it will just be, Brunetti will just be sort of cleaning up where TAM left off. They might just simply follow the Federal Circuit on content-based discrimination and simply say, okay, it's unconstitutional, or they might find that it's compelling. It's hard to say. But I think, one possibility is that this is not a case where it's going to reverse the Federal Circuit. And the Supreme Court doesn't always reverse the Federal Circuit, even though people expect that. It's only in about, if I remember, about maybe 3/4 of the cases where it reverses, so there's still 1/4 of the cases where the court has granted cert that it's actually reversed, or is actually, has affirmed the Federal Circuit in a 1/4 of the cases. Maybe this will be one of those 1/4. The other possibility is to simply distinguish TAM, reverse the Federal Circuit, and reach the conclusion that the USPTO can deny registration for marks that are found to be immoral and scandalous. Maybe it will lay out some standards for that, or maybe say that what the USPTO is doing is okay. That may be a harder one to say what the USPTO is doing is okay. There's a lot in the evidence about how, for the same term, sometimes the USPTO has found it to be scandalous or immoral, and in other cases it hasn't. So there's some bit of unpredictability that certainly would concern the court, and it may not want to increase the unpredictability by distinguishing TAM and reversing the Federal Circuit. But if the court does want to allow the USPTO to keep the federal registration from being flooded with marks that the general public might find offensive, or there might be some question as to the vulgarity of the mark, maybe they will try to create an approach that gives the USPTO some flexibility while still upholding TAM. So I'll be back with a roundup on all the Supreme Court intellectual property and technology cases when the term is finished in June. But these are my predictions. Brunetti was a closely watched case, and it's worth, I think, spending some time on. So thanks for listening. You know how to contact me, and look forward to the next video where I talk about the full set of cases from this term.